you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do?
The Democratic Party's lawfare strategy to defeat Donald Trump took another blow at the end of September, not that the media gave it much attention. 3 prosecutions have already hit snags, and now a New York appellate court has expressed considerable doubt about Attorney General Letitia James's $489 million fraud prosecution and verdict.
May it please the court, Judith Vale for the New York Attorney General's office.
A 5-judge appellate panel heard Mr. Trump's appeal of a lower court judge's penalty for allegedly inflating the value of his real estate assets to obtain better loan terms. But before the Deputy Solicitor General from the AG's office had even started, Justice Friedman jumped in with this, a question that judges repeatedly came back to.
All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners?
What made Attorney General Letitia James's lawsuit so unusual when it went to court was that nobody claimed to have been harmed by the former president's alleged legerdemain. That's ordinarily required in fraud cases.
And it was using...
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Prior cases brought under the state civil fraud law involved corporate actions with large numbers of assumed victims, such as banks withholding money from customers. But this was different, said Justice Friedman.
I mean, you've got 2 really sophisticated parties in which no one lost any money.
Going further.
Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
Justice Moulton also questioned the staggering $489 million penalty.
The immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Letitia James literally campaigned for her office on a pledge to prosecute Mr. Trump for something.
I'm running for Attorney General because I will never be afraid to challenge this illegitimate president. I believe that the President of these United States can be indicted for criminal offenses, and we would join with law enforcement and other attorneys general across this nation in removing this president from office.
The job of appellate courts is to take a detached look at how the law is applied to protect due process, especially for politically unpopular defendants. Doing so in this case is both crucial for the rule of law and for future defendants in New York State.
With that sort of historical backdrop to this law, how do we draw a line, or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312, and when she is going into an area that wasn't intended for her jurisdiction?